Okay. Calling the matter of People State of Michigan versus Shane Wade Sims and Chelsea Ann Sims. Both are charged with count 1, assault with intent to great bodily harm, less than murder or by strangulation. Count 2, assault, felonious assault. Detective Robinson, identify yourself for the record.
Detective Kenneth Robinson, Canton, please.
Okay, you remain under oath. Will you be testifying based on personal knowledge and or information?
Yes, sir.
Go ahead and proceed.
Yes, sir. On July 14th of 2023, the defendants, Mr. and Mrs. Sims, and the victim, Bree Dixon, were involved in an altercation in a vehicle, basically a road rage incident. Miss Dixon pulled into a parking lot at 39605 Ford Road, which is located in Canton Township, at which point the defendants, the Sims, also pulled into the parking lot and pulled in a position to block her from parking her vehicle. Mr. Sims exited his vehicle along with the victim, Mrs. Dixon. They had a verbal altercation. During that altercation, Mr. Sims, who had retrieved a bat from his vehicle, struck her in the upper body. Mr. Sims then disengaged that altercation and went back in the vehicle, at which point the victim, Mrs. Dixon, and Mrs. Sims, Chelsea Sims, had an altercation, at which point Mrs. Sims struck her 3 times with the bat in the upper body and kicked her 1 time in the face.
What was the extent of injuries from Ms. Dixon? Were there any? Did she seek medical treatment?
She did not seek medical treatment. She did have a cut on the bridge of her nose and bruising on her right shoulder.
Okay, the court satisfied that probable cause has been established. All right, Mr. Reagan, that's the arraignment.
Your Honor, Reagan, on behalf of Mr. Shane Sims and Ms. Chelsea Sims, would waive the formal reading as to both individuals. Stand mute.
All right, not guilty plea be entered. Mr. and Mrs. Sims, identify yourselves for the record.
I am Chelsea Ann Sims.
I am Shane Sims.
Okay, argument is the bond, Mr. Reagan.
Judge, Ms. Sims is 42, Mr. Sims is 39. Neither have any prior criminal convictions, neither on probation or parole. Ms. Chelsea Sims, she's a general manager, Judge, at a hotel out in Wixom. Mr. Shane Sims, he is employed at Avis Ford, Your Honor, where he has been employed for a while. They both have a child at home, Your Honor. Again, no prior contact. This is an alleged road rage incident, so there's no relationship with the complainant in this matter. They both have strong ties to the community. They live in the community, have so. You know, I'm asking the court, obviously, to release them on a personal bond, have no contact. I don't think a tether is necessary because they don't know who the complainant is, so there's no reason for any contact with that person. Now, again, Judge, you know, no prior criminal history whatsoever. So I'm asking the court to consider these are just allegations. Obviously, they're serious, but there was no medical attention sought by the complainant at this time. So I'm asking the court to consider a personal bond, Your Honor.
Detective Robinson, who was driving? Which one of the Sims was driving the vehicle?
Mr. Sims, sir?
Okay, is there anything you want to add as to bond?
No, sir. Actually, this is no contact with the victim.
Okay. Mr. Weiner, we're working on some paperwork. Elijah Lewis.
You want his right now?
Yes. I guess we can proceed if you're ready.
Really can hear
Oh, here we go.
Okay, Ms. Ballard. Ms. Ballard, I just want to remain on mute. You can serve and watch, okay?
Okay.
Okay, just put yourself on mute.
All right. I gotta see how to do this. Okay.
All right, Mr. Weiner, are you ready?
Good morning, Mr.
I'm
Brock.
ready to proceed,
Morning, sir.
Judge.
Mr. Brock, you've been
Okay.
indicted with the offense of tampering with evidence as well as a possession of a
Calling case
controlled
number
substance.
235789601.
Daniel Ansondo has
People
been
say the
appointed
Michigan
to
versus
represent you, but
Elijah
this morning, Ms.
Lewis.
Yando
Mr.
will be
Lewis,
here
identify
to.
yourself for the record.
Elijah Lewis.
Okay, Mr. Weiner, this is Magistrate William Burton. Appearance, please.
Judge, Arnold Weiner, WEINER, P number 22104, on behalf of Mr. Elijah Lewis. Judge, I would normally waive the reading. I do not know what the actual charges are. I went and saw Mr. Lewis at the jail, at the hospital yesterday, but did not have a chance to find out what the actual charges are. If you could just
Okay.
briefly, thank you.
No, I will read the charges. Mr. Lewis, you are charged with the following counts. Count 1, child abuse in the second degree. Did knowingly or intentionally commit an act likely to cause serious physical or mental harm to a child by shooting into a vehicle where the child was. Count 2, child abuse second degree. Did knowingly or intentionally commit an act likely to cause serious physical or mental harm to a child by shooting into a car where the child was. Count 3, felonious assault. Did make an assault upon a Charnel Armstrong with a dangerous weapon, to wit, a handgun, without intending to commit the crime of murder or to inflict a great bodily harm less than the crime of murder. Count 4, did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit, to wit, child abuse in the second degree. Count 5, did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit a felony, to wit, child abuse second degree. Count 6, felony firearm, did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit, to wit, an assault with a dangerous weapon. Those are the 6 charges filed against Mr. Lewis. Does that satisfy your request, Mr. Weiner?
Yeah, I just want one clarification. Counts 4, 5, and 6.
Those are felony firearm counts.
Okay, felony firearm. That's right. I just wanted to
Okay.
make. All right, thank you.
Okay, argument as to bond.
Judge, with regard to the issue of bond, there's 2 ways I'd like to approach this. I know Mr. Lewis is 25 years old. You have a history of him. I know he's on probation for CCW. I believe I may have even represented him, but I know the family for a long time. I don't think there's ever a question of him not appearing. What I am going to ask is kind of a bifurcated request, Judge. I would like to have a reasonable bond that he may be able to make and go out, perhaps even a 25 or a 35,000, 10% bond. But if the court, because of these charges, and they are serious, I understand that, it is not inclined to go down to such a low, a bond of that proportion, I would request that you allow him to stay in his house under a strict, with a GPS tether, a house arrest, and for the following reasons. Number one, whether you are aware of or not, in this instance, he was shot by other people in that other vehicle. And as a result of being shot, he's in the hospital now. We do not know when he's going to be released, but he was shot in the leg above his ankle, but the more serious wound occurred when he was shot in his cheek, and it went up and out through his nostril. And there are some, as of last night, speaking with the nurses, there are
some fragments still in his nostril, and all of his teeth on the left-hand side of his mouth have been knocked out. You can see when you view him, his whole left side of his mouth by his cheek is all swelled up. They are also telling me that he's not going to be able to eat any solid foods for quite a while because of his injuries. And two, once this pain medication gets off of him from the hospital, he's going to be in some serious pain. So these are the reasons that I am requesting that if we can't make it a bond that he could get out, I would ask this court to impose a house arrest bond with a GPS tether, and the only provision would be for him to go to and from any medical appointments for these injuries. Because I know from my experience, and this court does too, that there's no way that the Wayne County Jail is going to be able to give him the type of medical treatment necessary for these injuries. So that is my request. In addition, he also works full-time in a lawn service company that also does irrigation. And he has 3 children, but one of the children resides with him, 2 years old. He takes care of him full-time and lives with his father in Redford. Those are all the facts that I'm aware of in making my request to court to use its discretion in establishing a fair and equitable bond where he can obtain the treatment necessary. Thank you.
Okay. Thank you, Mr. Weiner. You make some compelling arguments on behalf of your client in light of his injuries. The court knows you represent that he's on probation for CCW. These are very, very serious allegations, assault allegations, and that as a result of this incident, your client was shot as well while he ends in the hospital. For the following reasons, the court is going to grant you, in part, what you requested, Mr. Weiner. The court is going to impose a $35,000 personal bond with the following conditions. Give me one moment. Okay. The court is going to impose a $35,000 personal bond with the following conditions. You're not to possess any handguns, weapons of any kind. You understand that?
Yes, Your Honor.
You're not to have any contact with Chanel Armstrong. By no contact, that means verbally, in writing, via email, via social media, or through a third party. Do you understand that?
Yes, Your Honor.
While this case is pending, I don't want you to do any driving at all.
Yes,
I don't care
Your
whether you have a valid driver's license or not. You're not to be driving a motor vehicle.
Yes, Your Honor.
And per your attorney's suggestion and recommendation, which is why I'm not setting a cash bond in this matter, after you or just before you leave the hospital or as you're leaving the hospital, you're to be fitted with a GPS tether. You'll be on the house arrest after leaving the hospital. You're free to go to your medical appointments after you're fitted with the tether. But outside of that, I want you under house arrest.
Okay.
All right? You have
Yes,
a probable cause. You have a probable cause conference date of July 24th, 8:30 a.m. in front of Judge King. You have a preliminary examination July 31st, 8:45 in front of Judge King. Mr. Lewis, do you have any questions regarding your bond conditions and/or court dates?
No, Your Honor. Is it possible I can talk right now? Can I?
Well, you talk to your attorney.
Judge, I want to ask one question.
Sure.
That PCC on July 24th, would you know if that's by Zoom or in person now?
I believe it's by Zoom, but check with Judge King's courtroom to confirm.
Okay, thank you.
Is there anything else, counsel?
No, sir. No,
Okay, and like I said, any other questions, Mr. Lewis, regarding your bond conditions and the court date? Those things alone.
No, Your Honor.
You know what, Judge,
All right.
one question. When the hospital says he's able to be released, is he gonna be taken down to the sheriff's department to put each other on?
I don't know about that, but I would suggest that he report to the Wayne County Jail or DDC to get fitted with the GPS tether as soon as he's released.
Okay.
Okay.
Or would you allow a private company, because I have one that works exclusively with the courts all the time, to put their GPS tether on him?
I don't have a problem with that so long as it's a compliance with the Wayne County Jail.
Okay, thank you then.
Okay, do you want me to put that in the order?
Yes, sir, I'd appreciate that.
And was a private GPS tether company allowed?
Okay, thank you.
I understand it costs a little bit more, but I understand. Okay, anything else?
Yeah, we may be able to get him out quicker then, because once he's released, he may wait in there for another 8-9 days still. Because I know they're
Okay. Well,
All right,
regardless, I want him on a tether.
Absolutely. Thank you.
Number 30, People versus Kelly Messenger, 22683 FH.
Who's there for the people?
Hi, Miss Messenger. How you doing? Can you unmute? I know you're good at Zoom, Miss Messenger, so I know you can do it. Okay, your phone is, oh, there you are. You're, I can hear you now. Can you hear me?
Yeah, I can hear you.
Okay, good. All right. Mr. Danner, is there a victim impact statement or restitution request in this case?
To Ms. Messenger, we do not have any victims present.
No, I got it. It was like muted. It was muted.
And nor do I believe there was one to be read, according to how there isn't one to be read either.
Okay. Ms. Messenger, did you have enough time to speak to Mr. Gaddy or Mr. Ward about your sentencing today?
Yeah, I talked to him.
Okay. Have you had a chance to review the pre-sentence investigation and the recommendations?
Yeah.
Okay. As to the guidelines, Mr. Gaddy or Mr. Danner, any corrections?
I did not have any corrections as far as the guidelines. I have that.
Oh, Mr. Ward.
Your Honor, on behalf of Ms. Messenger, no additions, corrections, deletions to the sub.
Okay. Ms. Messenger, is there anything you would like to say before sentencing or Mr. Ward on her behalf?
Yeah, the only charge you gave me is the one where I hit the officer with the lock in the socket.
That's what we're here for.
All right, look, this prison is real fucked up. It's literally corrupt. I'm trying to tell you something. People get treated foul as hell here, and I was sticking up for somebody because the lady, this girl was about to go home, And I said she was on suicide watch. And I'm like, ask her what's wrong. I was already in state because I already hit right? And I'd already been on the work back all year because they keep doing shit to me, man, and to my peers. So she was on suicide. I'm like, yo, what happened? She said she about to go home. She on parole and shit. She about to go home. And I'm like, what happened? She got suicide watch crying and shit. She said, oh, it's a light on her. And I'm like, that shit happened to me twice. And, my baby been on the knees crying for about 13 years for her mama to come home and shit. They did that shit to me twice. Like, that's foul as fuck, man. They tearing people away from their home, their families. I brought suicides here where the warden come in at like 4 o'clock in the morning, right when the person's dead in the room. I was just saying, like, that's foul as shit, man. Then when the motherfucking inspectors come up here to talk to us, detectives, the nigga high as hell. And he's like, you know what I'm saying? I'm like, what the fuck, man? And they let that woman die in that cell. There was 2 officers in the cell. Like, no, I'm not making a joke. I'm not doing. What the fuck is so funny, man? They tearing people away from their homes and families. So I did that shit, man. That's foul as shit. And I'm
Okay, Ms. Messenger. I hear you. Mr. Ward.
And I'm gonna continue to do shit like this.
Muter.
You know what I'm saying?
Your Honor,
you know what I'm saying?
I understand you, Ms. Messenger.
and I apologize for Ms. Messenger's language. She's obviously very emotional about this, but she did take responsibility, and we'd be asking the court to follow probation's recommendation.
Because Ms. Messenger did take responsibility, and I understand that she did have her reasons for doing what she did, but it still doesn't give her the choice as to whether or not she violated the law, and which she did, and there was a finding as to that. As to count 1, assault of a prison employee, the guidelines being 22 to 38. I sentenced her to the bottom of the guidelines, which is 22 months to 5 years in the Michigan Department of Corrections. Credit for 0 days served to run consecutive with her current sentence. I'll assess a $68 state cost and a crime victims assessment fee in the amount of $130. I'll strike conditions 3 and 4. Ms. Messenger, those were the requirements that you pay $1,611 and attorney's fees of $650. Given your incarceration status, I'll make a finding of indigency and I'll strike those conditions for you. So it's just the state cost and the crime victims assessment fee and the time. Will you be giving her an appellate rights form?
Yes, we'll be mailing that to her today.
Okay, and Mr. Ward's going to email you the appellate rights form, and you're entitled to file an application for leave of today's decision. The form explains important rights regarding the appeal. The court will appoint a lawyer for you to appeal if you are financially unable to afford one. Should you want a court-appointed attorney, you must make your request in writing within 42 days from today's date. You want to? Is there anything else you have, Ms. Messenger? Do you have any questions about today's sentence? She's muted again. You are muted again. Ms. Messenger, if you do have additional questions, I'll allow you to proffer those through Mr. Ward at the Public Defender's Office. Mr. Danner, do you have an order?
Permission to approach with the order of dismissal for count 2.
Okay, we have the order of dismissal. There you go, Ms. Messenger. I can hear you now.
All right, dog. Look, ma'am, listen. So I had told you I didn't need a lawyer from the jump. I told you, look, I'm guilty. You like, oh, you gotta have a lawyer. Why, just to rob me for $600 and shit? Look, I'm tired of this shit.
I waived those fees. You're not picking up what I'm laying down. Those are fees I have to assess you, but I waived them. You don't have to pay them.
Okay, well, this prison is found. Can you appoint me a attorney, a court-appointed attorney for some civil cases? Because they've been coming.
I can't.
And there's some real violence.
But Mr. Ward can help you out, okay? Mr. Ward, you should make a referral for her. Okay, Ms. Messenger, Mr. Ward will be in touch with you and he can make a referral for you, okay? Best of luck to you. Okay.
They owe me.